before. What you need to do is call the debt settlement team at the Shah Peerally Law Group PC. They have an excellent record of getting your debt reduced at a fraction of what you owe. The best part is you don't pay a penny until a settlement is reached. Stop wasting time and money and call the Shah Peerally Law Group PC at 510-742-5887. That's 510-742-5887. Get out of debt now. This is just an advertisement. No attorney-client relationship is created by this ad. The law firm does not guarantee success.
The Shah Peerally Law Group is now opening its second office in San Francisco. After years of popular demand, the law group has finally decided to make the big jump and has its presence in San Francisco. For more than 10 years, the law group founded by the prominent attorney Shah Peerally has been dedicated to the immigrant community. The law group's new office is opening on February 20th, 2015, at the corner of 21st and Mission Street in the great city of San Francisco. For more information, call 415-643-4342. Or
if you would like to find out how you can get rid of your credit card debt for a fraction of its value, call 510-742-5887. Due to the uncertain economy, many people have settled their debts for a fraction of its value. It's recommended to use an experienced lawyer to deal with it. Shah Peerally is an experienced debt settlement attorney and has handled hundreds of such cases successfully. There are no upfront fees for debt settlement. Only when you win, you pay. Call Shah Peerally, attorney at law, at 510-742-5887 or visit yourdebtsettlementattorney.com for a free assessment. This is just an advertisement. No attorney-client relationship is established by this ad. The law does not guarantee success. Call 510-742-5887.
are you an H-1B visa holder? Do you have an I-140 petition approved or have an extension under AC-21 provisions? Are you on H-4 visa? If yes, we've got amazing news for you. As of May 26, 2015, you or your spouse on H-4 visa might be eligible for a work permit, aka EAD. And to apply, you need a lawyer who knows about H-4 visa issues. Lawyer Shah Peerally has been at the forefront of this fight for H-4 rights and has actually helped make this dream a reality. Now, his firm is ready to help you or your spouse get their EADs. Call 510-742-5887 or visit www.splgpc.com to apply for your EAD. This is an advertisement. No attorney-client relationship is created by this ad.
And now, from the San Francisco Bay Area studios, KLOK proudly presents to you the prominent attorney Shah Peerally for the Shah Peerally Law Show, coming at you with over 50,000 watts of power. The Shah Peerally Law Show, where all your views matter.
Hello, everybody. Assalamu alaikum, Sastikar, namaskar to all the listeners. This is attorney Shah Peerally for the Shah Peerally Law Show, and we're doing live. I know Liz announced earlier that this is going to be a recorded show, but luckily I was able to liberate myself, so I'm going to do the show live right now. So feel free to call. The number to call to the studio, of course, is 408-912-5565. 408-912-5565. We have a lot of things to discuss on immigration, including one important things which I didn't have time last time to discuss about is this famous amendment on H-1B, which is becoming mandatory now. And we're going to cover a little bit when is it mandatory or not mandatory to do the what we call the H-1B amendment. And this is based on a case that came out from the Administrative Appeal Office, the AAO, and this case is named Matter of Simeio, I hope I'm pronouncing it right, Solutions, LLC, and it basically covers the issues. There was also what we call a question and answers that was issued, and I published that also with a slide on immigration legal blog. So you want to check this because this is very important, because this is going to determine the status of your what we call your H-1B situation. So please make sure that you listen carefully today. I'm going to take calls in a few minutes, but I am going to go over that entire thing because this is major, and a lot of people are asking me what it is about, when do I do that, when do I don't do that. But the truth is that all this was laid out before, but now they just made sure that people are doing it. So before I start, ladies and gentlemen, this is Attorney Shah Peerally for the Shah Peerally Law Show, and today, everything I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And just to let you know, this is a live show today. It's not recorded, so you can feel free to call for any immigration questions. But I will be starting taking questions in 4 or 5 minutes because I want to cover that. I've been talking a lot about H-4 EAD. That's going on, so if you need help, feel free to call our office, 510-742-5887. But today I am going to talk a little bit about the H-1B amendment, which is something major on the front of H-1B, and also USCIS announced the number of applicants. It seems like they had 233,000 applicants, including the fact that they took some from the master's degree. But I'll talk a little bit about that later. But let me go over the amendment because this is major, like I said. So what the USCIS is saying based on this case, the matter of Simeio LLC Solutions, is that and whenever you change location for your H-1B staff, if you are an employer or if you are an employee who was on H-1B, there are situations you have to do what we call not only an LCA, a new LCA, but you also have to do an amendment of the H-1B, and that goes within the purview of what we call the material change. Material change can be a lot of things, and in this question and answers that USCIS covered, they are talking mostly about job location. Okay, so I'm going to cover the job location part, but there might be other material change where you will need to do a change of amendment of a H-1B. So if you need help, of course, 510-742-5887. So first of all, let me go over that question and answer that was issued by USCIS on May 19th. So first of all, they explain before you place the employee, you need to file the amendment petition. I say before that, if you're putting them in a new work site area, you need to amend the petition. It's very important. But that means once you amend it, can they continue working? Yes, because you have to have the LC approved. The question is, when should the amendment petition be filed? Well, it should be filed when you're changing a work site location, so what we call the Metropolitan Statistical Area, the MSA, is changing. Okay, for example, if you are, what they took as example, for example, if you're moving in the Santa Clara area, one job to another, and you can just file only the LCA. You don't have to file what we call the amendment petition. But once you go outside this Metropolitan Statistical Area, MSA, you need to do what we call not only the LCA but also an amendment petition on your H-1B, and this is major. And if you don't do it, ultimately your H-1B employee or if you're an H-1B will be void, kind of. So they will revoke it. So make sure that you're doing the right thing. So, ladies and gentlemen, this is a very important issue that we are discussing here today. This is Attorney Shah Peerally. And, of course, we will be taking calls, like I mentioned, 408-912-5565. But I want to cover this amendment petition issue because I'm getting a lot of questions on that, so I will try my best to clarify for people. So what they say also, if you're moving within that MSA that I was mentioning earlier, you just need to do what we call an LCA, a new LCA, which is a labor condition application. That means only the Department of Labor needs to be informed. And the example they give is if an H-1B employee moves to a new location within, for example, New York City, they will not need to do a new LCA, but you will still need to post the previously obtained LCA at the new work location. So in this case, you don't even have to do the new LCA, but you have to at least, and I correct myself on this because this is confusing too, what they're basically saying, I'm using New York City, but we're not in New York, so we are looking at the situation which is here in California, but you have to still post it. So make sure that you're doing the posting as required. And if you're doing short-term placements is like, for example, if someone is moving just for 30 days, you're sending them, for example, you have a company X and you have to work on a job site. This applies a lot when you're doing IT or civil engineers, where you have to place that person suddenly to a small one place. So you need to go ahead and do what we call you don't need to do either an LCA or an amendment. But now let us non-work site. If you are talking about non-work site location now, so if an H-1B employee is only going to a non-work site location, you don't need to file an amendment H-1B petition. And a non-work site, basically a non-work site is going to be when you're developing something. For example, you have a software to develop at your client's place, and if it is temporary, you don't have to do that. And also, some jobs require what they call the peripatetic in nature jobs. Those are jobs that require that you send the worker for a certain number of days on certain areas. And I know for civil engineers and things like that, this is something major because they have to do it. Then you don't have to do a new LCA. But apart from that now, when you really need to do the LCA is when you're moving those applicants to basically different areas. And for example, one of the things that is very important is if you are changing jobs, and that will apply a lot to IT consulting firms. Oftentimes they are placed in one project and suddenly they move to another project. In this case, you not only need to do an LCA, you need to do what we call an amendment of the H-1B. Make sure you're doing that. And they even want people for past cases, since the law was not clear, you have until August 19, 2015 to do all your amendment of H-1B. So if you have any questions, you want to know more about the amendment, please give us a call, and we will help you. The number to call is 510-742-5887. It is very convoluted, but if you look at it in simple terms, as soon as you move outside the MSA area, MSA area, you have to do what we call not only the LCA, the amendment petition. I have one caller. Let me take the caller. This is Shah Peerally. You're live in here.
Hi, Shah Peerally. This is Jay.
Hi, Jay. How are you?
Yeah. So I have a question on the H-4 EAD rule, right?
Yes.
So here's my situation, and then maybe you can help me, really recommend the right option here. So my wife is basically, she's on OPT right now, and we're trying to see how we can, instead of filing for H-1, given the lottery scenario, we want to explore the H-4 EAD option, right? Given I'm on H-1.
Yeah.
But the thing with H-4 is once she switches her OPT to H-4, she would be on H-4 and she still use her OPT, right, until she gets her EAD, because there is going to be that time period where, she's on H-4 and she gets her EAD. So how do we address that, right? Because I'm assuming she can't work. Or if you say that she can still use her OPT once she's on H-4, then what is the best way forward, right?
Okay. Actually, I wrote something about this 2 days ago on the blog h4toead.com. h4toead.com. Should someone keep on the OPT or move to H-4 EAD? Yes, there might be a lapse, and there's a big chance there will be a lapse, because by the time the H-4 gets approved, you are talking about a couple of weeks before you get the EAD. The mistake people make is they think they will go ahead, process the H-4, and then start the process on the EAD. No, it's going to go simultaneously, but until the H-4 gets approved, they will not send for the card production. So the way it's addressed technically, officially, this is the rule. You cannot work once the H-4 gets approved. However, let's say she doesn't know that she has been approved, and let's say hypothetically she continues working. Technically, there's a law called INA 245K, Immigration Nationality Act 245K, which kind of forgives you for unlawful work for 180 days, aggregate and 180 days. So basically, if in case this situation is happening and by mistake she continues working, it won't affect her in the future. And of course, that depends on the employer, and many employers will not agree to that. But there's no solution really, except there's a defense if in case she does it. But that doesn't mean people go and use it as a tool. It is just a defense. But there's no real solution for that. That's why I'm telling people think and do a consultation on a case-by-case basis if it is a good idea to move to H-4 EAD now, or wait when the OPT is complete, then go for your H-4. Excuse me.
Oh, okay.
So at this point, there's no real solution. There's only a defense. Okay?
Okay. And now, just to follow up on that, so the H-4 EAD times, right now they're saying they could take anywhere from 3 to 3+, right? I'm assuming there's going to be a big queue of applicants given the rule is just out. So again, do you anticipate the timing of the actual approval?
Yeah, it will be delayed. Originally, I was thinking by 90 days people will get it. Yeah. But I'm thinking now it will be more like 120 days. The reason for that is there's a shortage of people already at USCIS. And right now also there's a lawsuit that is going on people who are delayed on the EAD. So based on all those factors, I cannot really give it timing, but I'm hoping that because of that lawsuit, they will put more people to work on the EAD, and that will clear everybody. So it can cut both ways. They can go fast or they can go slow, depending how this lawsuit has been filed by a bunch of people, not for H-4 EAD, but for regular EADs, and they are the same department. So I'm thinking between 90 days to 120 days. Okay?
Okay. I do have one last question. Do you still have time?
Mm-hmm. Yeah, go ahead.
In that context, right, so assuming we do take a break, now from an employment perspective, the legality, so can a person still be employed with the company but not be working because out of status and then start working like after 2 months or something like that? Is that still a possibility or just going to be like...
Technically, no, but if an employer gives you a break, there's no reason an employer cannot take you back. So it's pretty much something that has to be decided between the employer and you guys. It's legally, as a lawyer, only answer I can tell you, no, you cannot be employed when you don't have a work permit. Having said that, the INA 245K, let's say even the employer makes a mistake, continues employing you, it won't affect you as long as you don't aggregate 180 days. When I mean aggregate, it means for your total lifespan. You cannot use more than 180 days. So read that article. It covers this, or give me a call at the office. We can decide on your case because each case is different and there are different solutions for different people. Okay?
Okay.
Good luck to you. And the whole article is on that website, H4TOEAD, H42EAD.com. You have to put www in the front. I don't know why, but you just do that, and then you will get a lot of answers there. Let me take another caller. This is Shah Peerally. You're live on air.
Hi, Shah. Thanks for taking my call. I have a question. I applied my brother in 2011 I-130. I'm a U.S. citizen, and we received a notice for put more evidence about my brother, but their date of relationship, paperwork. I did submit it. Now I received a letter saying denial and appeal within 30 days. How can proceed this case now?
Well, this is the thing. Until I see it, I will not know exactly where it went wrong. But most of the time, the denial we're seeing, this is something which is happening more and more frequently now. And it's usually based, you have not proven the relationship between you and your brother. You have to give me a call. I'll look at what is the reason of the denial, and I'll tell you if it can be appealed or a motion to reopen can be filed. But so far I've got a bunch of those cases coming up right now. So people, that's the unfortunate part. They tell you it's easy to file those forms, and if you don't file it right, they will deny it, and they are becoming very fast they are moving very fast in denying people right now. So let us check if they made a mistake or you have good reasons you can prove your case. You should be able to reopen it. Okay?
Can we do like a DNA test and put those things in there?
Well, you can do a DNA test. The problem is that for sibling DNA test, they say is not reliable. That's what they say. I'm not an expert in DNA, but this is what they put on their paper for siblings DNA. But yeah, it's a good idea to do a DNA test and try to reopen the case. But you need to do that very fast. And if you need help, just give me a call. We'll help you at the office. Okay? The number 510-742-5887. Let me take another caller. Hello, this is Shah Peerally. You're live in here. Hello.
Hello, Mr. Shah. Thanks for taking my call.
You're welcome, sir.
I have a question. I'm on L1A visa, and currently I'm on I-94, but my visa is there. My L1 is valid for next 4 more years. And the thing is, I have got another H1. I have got H1 sponsored by another employer, and in that case, it is filed as a change of status. So after beginning of October, I have to join the new employer. So my question is, in case my current employer wanted to process my green card, say in September, can they do it?
I didn't get what the last part you said. So your
employer wanted to. My current employer, in case my current employer wanted to process my green card, and it starts the process in September, beginning of September. Can they still do it, or they cannot do it because I'm getting change of status by beginning of October?
No, the green card is not stopped. Even you move to another company, it's not stopped. But if you move to another company, they might stop the green card. So if you want to stay on the L1, one of the tricks you can do, just leave the country and come back you have already a stamp of the L1. You can go ahead and just come back. It will reset it, and you will still be in the H1 quota, but you go ahead and you enjoy back on your L1. L1 depends what L1, L1A or L1B, but no, even you move to company B, if your employee A wants to continue your green card, it's totally allowed, but most companies won't do it, and it might become difficult a little bit for them when it becomes the issue of ability to pay. But no, nothing prevents you from continuing your green card. It all depends on the company policy, okay? And if you want to go back on the L1, just leave and come back.
I cannot go out of country because my visa is already expired. So I'm on I-94 right now. So in that case, I cannot go and come back, right?
Well, you can go and come back if you go to Mexico because then you have NAFTA. But this is very tricky. If the visa is expired, then I have to look at it. But you can also do an amendment on the H-1B, change it from change of status to consular processing, and then you keep your L1. So those kind of cases requires a lot of dexterity, and the lawyer needs to know how to do that. And unfortunately, maybe the company lawyer might not be happy to do it. So give me a call at the office. I'll see what is the option for you. If it is a good chance to just go and get a stamp, you can go and do that. But if you want to continue on the L1, you need to amend that H-1B or leave and come back, okay? And you need a stamp if you leave and come back, okay? And the stamp will not be hard if the company is strong, okay? Huh?
Sure. Thank you.
Okay, good luck to you. So if you need help, 510-742-5887. Let me take another caller. This is Shah Peerally. You are live on air.
Hello, Mr. Shah.
Yes, sir. How are you?
First of all, I would like to thank you for all the hard work you did for getting the for getting the EAD for H4 visa holders. It's really appreciated.
Oh, thank you so much. I appreciate this. Makes a lot of difference when we hear people thanking us for that. But I'm very proud it happened. It was very important.
Yeah. So I had a question. I was going through your website, H4 to EAD, and there was this one blog that was added yesterday which says H4 visa holders can apply for green card.
Yes. Yeah, this is actually I give 2 examples of on that post when I posted it yesterday because one of my clients who I did that just became a citizen, and I wanted to. It just reminded me that an H4 can apply for a green card. I tell you why. Because an H4 is just like an H1, okay? and H4 is a dual intent visa. Even at the time when there was no EAD, you are eligible to file for a green card because there's nothing wrong in that. Of course, if you are born from India, and fortunately there is a delay if you go on EB2 or EB3,
correct.
But nothing prevents you from filing it. There might be other issues, technical issues like ability to pay because it's for future employment. But now with the people having an EAD, what I was thinking, let me give you a scenario. You have H4 EAD, the employer likes you, paying you good money, and the employer wants to file your green card. Let them file the green card, and then since you're already being paid probably the prevailing wage, then what happens, they will have it easy to file the I-140. And this is a good backup. People can file also under that, and the I-140 and their green card. Same rule as H-1B, no difference.
Mm-hmm. But I was just reading that blog, and it says even it can be filed on EB1. I understand it can be case by case basis also.
Yeah, EB1. You can file on anything that gives you the thing. The H visa. Forget about H1, HB, H1 or H4. The H visa is dual intent. So the intention of getting a green card is there. There's nothing wrong. So you can file. So if you qualify for EB1, some people do qualify for EB1. I have a case, for example, it was 2 years ago, where that person was completing her PhD. She was an H4. And with that PhD, plus also she got some major publications because of some of the work she did, and she went to school under H4. And then what we did, we went ahead and filed an EB1B for her because the school offered the job, and since EB1B takes only like 4 or 5 months to get processed, she got a green card and started working for the university. It was a university. So, yeah, you can do EB1A, EB1B, national interest waiver, anything employment you can do under H4.
Okay. So I'll give you a call on your office number. I just want to find out the eligibility and more details on this.
No problem. Please do that. And thank you for pointing that out because this is major. A lot of people are not realizing now it will be a lot easier because one thing from my perspective, many employers will not give you a chance because they don't know you. But now when they know you under the EAD, you're doing a good job, they will give you a chance. So take advantage of that, okay?
Sure. I mean, I also didn't know till the time I read this blog, so it's good.
Okay, good. Well, please do me a favor, pause that blog, share it on your Facebook, wherever you can share it. More people know, more it is good for all of us, okay?
Sure, I'll do that. Okay? Thanks a lot.
Thank you so much. I appreciate your kind words. So, ladies and gentlemen, we don't have any callers now, so I am going to go ahead continue on my H-1B amendment, but we got excellent questions. And like the caller was saying, this blog, the H4 EAD, is getting a lot of hits because I know a lot of people are very interested in all the points I put there. What I have tried to do, I have tried to put together all the issues that are related. For example, the H-1B amendment, I merge it with what will happen to an H-4. What I did also is for the green card. And the idea is there is to come up with scenarios where people can get answers even before talking to a lawyer. But, of course, a good lawyer who understands the whole concept can make a big difference. And I'm proud to say that our team just won an EB1B yesterday, and that person is very happy because her lawyer told her this was impossible. And she came to us and said, you try it. And I told her it was a 50-50 chance, and luckily we just won it. I think it was last Monday. We won it on Friday. And I'm very proud to say that we won this EB1B, and we are doing some major work even for some big names, and I'm very proud of that. And because of that, they have spoken to each other, and we are very proud that we are working on national interest waivers and EB1A, EB1B, EB1C. In my career, I don't take many of those cases because they're very selective, but the truth is that we have a very high success rate. I think I lost only one in my career, and I'm very proud of that, and out of so many. So if you need help, look into those national interest waivers, EB1A, EB1B, EB1C. Under the EB1A, for example, you don't need an employer. And the national interest waiver, the same rule. So sometimes it's good to have it, and you are not dependent on any employer. So, ladies and gentlemen, if you have any questions now, feel free to call. The studio lines are open, 408-912-5565, 408-912-5565. The big thing I was talking about, of course, is that famous situation of the H-1B amendment. There are many, many questions to be answered when it comes to H-1B amendment, and I have a very good slide on immigrationlegalblog.com. People ask me lots of times, why do you have a lot of blogs here and there? But the truth is that many times a lot of people want me to write on different blogs, and they end up by kind of giving me the blog to write on. So I keep writing on them because that's kind of a passion for me to keep writing. But as much as possible, I give information to people. But know one thing, most of my blogs have mostly what we call general information. So you need to make sure that you don't take the information in a wrong way. I'll tell you an example. One time, someone asked me a question about I-140 and I-45, and if someone leaves their job, does the employer have a right to cancel the I-140? But I answered, say no, because you have an I-45 filed. But the problem is that this person misunderstood, and he thought, and you have 180 days has passed. He heard only the 180 days, and he went ahead and he wrote. I saw he wrote it the next day on a forum, and this got really viral, and people thought, oh, if 180 days has passed, they cannot revoke your I-140. But that's not the law. The law only applies in the AC-21 if an adjustment of status was filed. So make sure you know it exactly, and you don't, because oftentimes those forums, especially those non-lawyer forums, like I see, and they are the one who has a lot of hits, a lot of disinformation goes there. So don't rely on those. Make sure you find a solution for yourself. And, of course, general information you can get, but make sure you don't get the wrong information. Let me take another caller. This is Shah Peerally. You are live on air.
Hello, Mr. Shah Peerally?
Yeah, this is Shah. How are you?
Hey, I'm pretty good, thanks. Thank you for an informative radio show.
Oh, yeah, thank you. Thank you so much for listening.
I have a quick question.
Yes,
my son is a U.S. citizen. A few months ago, he married a foreign national in U.S., and the girl left the country, and now we have filed I-130. We have the receipt, notice of receipt, and I was wondering, rather than waiting for that I-140 to be approved and then going for consular processing, I came across a visa called as K3. Is that visa a dual purpose, and can she apply for that visa?
Okay. Well, very good question. First of all, why did she leave? What visa she was on when she was here?
She was here on a visitor's visa.
You could have just filed an adjustment of status, not let her go.
No, actually, she had come for a temporary visit, and she had she's working, and she wanted to continue working, etc.
Yeah, you can file for the K3 visa, but from my experience, the K3 is taking longer than the green card process itself. And it actually sometimes hinders the whole process. So I am not using it on any case because lately the speed that the processing of the I-130 is going is faster sometimes than the K3. But yes, you can file the K3. Whichever comes first, you pick it. The problem is that when you file the K3, it stops it. It sends it to a different department. It might delay, actually. So it's your call. If you want to file it, yes, you can. But my experience says no, don't file it. But I might be wrong. In some cases, it is a good idea. I've seen cases where I told people, no, don't file it. And they told me, Shah, now you told me not file it, and my friend got it. So, but from personal experience, having worked with many of them, right now, the K3 was built back in the days when it was taking like 2 years to process. Now it's taking like 8 months, depending on the country where she's from. Which country, may I ask, she's from?
Oh, sure. She's from India, of course.
From India, yeah. It's taking 8 months to 1 year, and the K2 is taking 6 months to 8 months, even 1 year. So if you want to go ahead, file the K3. The problem is that if you do the K3, then when she comes here, you have to redo the adjustment of status, etc., etc. So it's your call. Usually it's not. Yeah, it is available, but I don't recommend it from experience. But I might be wrong on that. Okay. Okay?
Okay. And I-130, what's the typical processing time?
It's like 6 months to 8 months. 8 months to
Wow.
1 year maximum. Okay?
Okay. Okay. And after that consular processing?
After the consular, well, then she comes here on a green card under an I-551 stamp, and when she comes here 2 weeks later, they will hand her green card. Okay?
So after I-130, she can straight away come here, is it?
No. The case will go to National Visa Center, and then you will have to fill the DS form, the I-864, etc. They will guide you and pay the fees. Once this is processed at the National Visa Center, which is the State Department, it will be sent to the consulate for an interview, and they will question her about her marriage, etc. If she passes the test, she will get a stamp. She comes here, and then she gets a conditional green card if she's within 2 years of marriage. Okay?
Okay. All right.
If you need help on that, you can give me a call. And actually, I have on my website, Peerally, my main website now, splgpc.com. There's on the top you will see something called a how-to guide, and it will guide you what are the steps right there. Okay?
Sure. Can you repeat the website, please?
It's Peerally Law, or short is splgpc.com. splgpc.com, or just Google my name, it will pop up. There are many websites on my name, but that's the main website. It will pop up, PeerallyLaw.com. Okay?
Okay.
All right. Good luck to you. Thank you so much. Thank you, sir. Let me take another caller. This is Shah Peerally. You're live on air.
Hello, Mr. Shah. Thanks for taking our calls. I really appreciate your service and help online.
Oh, thank you. Thank you so much. I appreciate it.
I have one question. My son is an American citizen, and I just want to know when he can, after what age he can file a green card or something, whatever will allow us to stay here. After how many years? What is the process?
For who? For the parents?
For the parents, right?
Yeah, he has to be 21 years old. Once he's 21, he can file for his parents. For his biological parents, if he's...
Yeah.
Hmm?
But do they file green card, or what does they file at that point of time, and how long it takes generally?
It's an immediate relative. So if the parents are already here and they overstayed, or they didn't enter enter illegally, then it takes around 6 months to get it. And if the parents are outside, it takes like 8 months to 1 year. It's not long.
Okay.
All right. Okay. Good luck to you. I wish you all the best. Let me take one more call, and then we're going to take a quick break. This is Shah Peerally. You're live on air.
Yeah, hi. I got a question about I'm with employee A, and I got my 140, and I moved to employee B. They haven't filed my green card yet. My 3 years is going to be in this year. Do you need to file a new labor before 1 year of the 3-year extension, or can I still extend it? How does it work?
Okay, if your I-140 is still good with company A, they have not revoked it, you can use that to do extension beyond 6 years. However, down the road, if you want to get a green card, it is recommended to start the new process with that new company from labor to I-140 and I-45. So, no, as long as the I-140 is still valid, whether it's from company A or company B or company C, you can still use that for extension. It doesn't have to be the same company. This is under the AC-21. I think it's section 106A and C, if I'm not mistaken, and that's the law. Okay?
As long as I-140 is still valid, I can still extend as long as I want? Or you need to file it again with some time?
Yes, you don't have to refile. But ultimately, if you want a green card, unless you want to go back to company A, you will want to have a new green card started with company B. Okay?
Is there any way to know whether my 140 is still valid or no?
You can check online just punching the WAC number. But unfortunately, I had bad experience on that because sometimes they don't update it and you don't know. So the only person that will know is your employer. And just to let people know, this is important because the employer has so much control over the I-140. Right now, there is a kind of a lawsuit being filed. Not a lawsuit, but a petition with the USCIS to tell USCIS that people who benefit from an I-140, that they have control over that I-140. But until that passes, right now, only your employer can tell you and USCIS. Okay, the best way is to not be too optimistic and start your process with company B, so that just as a backup. Okay.
Okay.
Okay. Good luck to you. So let me take one more caller, and then we're going to take a quick break, ladies and gentlemen. This is Attorney Shah Peerally. Are you alive on air? Hello. So, ladies and gentlemen, we're going to take a quick break. I think I lost the call. I'm so sorry for that. And today I was talking about H-1B amendment, but then we talk about several things, including the H-4 EAD. As you know, the H-4 EAD is out. If you need help on changing status to H-4 or even the H-4 EAD itself, I know many people are filing on their own, which is a good idea, but at the same time, remember, this is a new law. There will be so many cases there. You don't want to take chances of any mistake. So if you need help, give us a call at the office, 510-742-5887. And the advantage I have pretty much is we have worked on this law for years to get it passed, and we have supported it. And we know enough about it to help you. So I wanted to thank Liz for helping me today. She has been very, very helpful. And we are not done yet. We're going to still be here, but we're going to take a quick break. And don't go anywhere. And anything I told you today is for educational purposes only. You should not act or refrain to act solely on the information provided. If you have any questions, feel free to call my office, 510-742-5887. The website to check, lgpc.com. So don't go anywhere, ladies and gentlemen. We'll be back.
Is your credit card debt driving you insane? Don't panic and claim bankruptcy. Don't consolidate and end up worse off than before. What you need to do is call the debt settlement team at the Shah Peerally Law Group PC. They have an excellent record of getting your debt reduced at a fraction of what you owe. The best part is you don't pay a penny until a settlement is reached. Stop wasting time and money and call the Shah Peerally Law Group PC at 510-742-5887. That's 510-742-5887. Get out of debt now. This is just an advertisement. No attorney-client relationship is created by this ad. The law firm does not guarantee success. The new Attorney On Air app is now available to download on your iPhone or Android. Get access to the latest information and interact on the immigration and debt settlement blogs. That's not all. The app has plenty of entertainment as well. Listen live to the Shah Peerally Law radio shows. Go to www.attorneyonair.com to download it for free. Yes, that's right, for free at www.attorneyonair.com. He has given you advice on immigration issues on the radio. He has brought you those same issues to the big screen, and now the man who's been looking out for your well-being brings you the story of a man exiled from his home country, only to find out how much worse his life becomes, seeking refuge in his new one. Shah Peerally presents the immigration lawyer, Asylum.